I've been busy this week. I meant to send him. I'll help support him financially. I like the guy a lot. So much more trouble than it's worth being. First of all, we don't send 26 cases.
Right. Yeah, that's well, and
oh yeah, absolutely. He'll be writing dissents. He'll be writing dissents all the time.
Exactly.
That's no fun.
Yeah. That's what. It was just so sick.
Oh, you know, I know. I feel bad for Brian. It's a long. I've known him. We clerked together.
Oh, did you really?
87.
Oh, yeah.
So I mean, I've known him that long.
Yeah.
And there was Judge Bell left the federal district before the election happened, and whoever won the election, I said the consent of the senators, we're going to get to fill that seat, one in Detroit. Well, it's a long and ugly story how this all happened. The original president that they were going to give one seat to a Republican, one seat to a Democrat, and he was all set to go. Yeah. And then the state got flipped, and he was going to be flipped. It's very sad. He was all set, and then having a decision having nothing to do with him, they decided to go the opposite and put a Republican in the Senate.
Yeah.
Okay, let's see what we have. Oh, we got everybody here. Look at this. Excellent. Can you all hear us? I just want to make sure we're.
Yes, yes.
I can hear you. Can you hear me?
I can hear you perfectly. Okay.
Great.
Just 1 second. I've got to switch my papers out here. We just finished another argument and then. Okay. All set. Great. We are now on the record in case number 23-000138-MZ, American Friends Service Committee against the Michigan Department of Corrections. We're here today because the defendant has moved for summary disposition in lieu of answering in responding to the first amended verified complaint. The request for summary disposition cites MCR 2.116C4, C8, and C10. Today, I think, based on my preparation, I want to focus on the C4 aspect more than the C8 and C10 arguments. I recognize that the movement has cited standing as a defect and has made some other arguments, but the one that interests me most is the one having to do with the manner in which the Freedom of Information Act request was processed and handled, because it seems to me that if you go through the paperwork, what you'll find is the defendant, Michigan Department of Corrections, received and dealt with the 5 separate FOIA requests, and in the process of doing so, prepared and presented a response to each one of the requesters, and in each one identified the number of pages and established a 50% good faith deposit, each one a relatively small amount of money, which was accompanied by a fee calculation in some detail. And then if you get to the most important documents, which I think are Exhibit 3 to the first amended verified Freedom of Information Act complaint, what you'll see is that the requesters then appealed to the director of the Michigan Department of Corrections, who responded with a form filled out with lots of detail. Michigan Department of Corrections Notice of Freedom of Information Act appeal, which acknowledged the appeal, explained the department's position in what I believe to be by far the most critical paragraph, said, your request is granted as to existing non-exempt records in the possession of this department falling within the scope of the request. No decision to deny any portion of your request has been made, as the department requires the previously discussed deposit to begin processing your request. Therefore, the department has no denial to uphold or reverse, as no decision on the denial of any records has been made. Now, in preparing for this, I wanted to let you know that I not only read again the Arabo case, ARABO versus Michigan Gaming Control Board, 310 Mishap 370, but I went back. I didn't have to take too long to remind myself of what our court said, the Court of Appeals in Michigan Record Company versus Department of State Police, an unpublished opinion from August 17, 2023, cited by at least one, and I think both sides, docket number 363736 from the Court of Claims, because I was on the panel. I didn't write the opinion, but I certainly spent a lot of time thinking about it. And you can try to talk me out of it, but I think that the Michigan Department of Corrections has it about right here, that the difficulty is that they required a deposit. They explained why they were requesting the deposit in accordance with MCL 15.234(8), and because the deposit wasn't paid, there was never any sort of decision on the merits to be brought before the Court of Claims. And at least I think under MCL 15.240(a), MDOC acted as one would expect. And what we have before us is a tardy effort to commence a civil action in the circuit court under MCL 15.240(a), small b, close paren. So anybody can try to convince me I'm right or wrong. Ms. McCormick, it's your motion. Why don't you go ahead first? I don't want to dissuade you from talking about everything else you want to talk about, standing or anything else you want to say, but I think you have a winner here under 2.116C4 because they did not pay the required deposit.
I agree, Judge, and I don't want to argue anything to the contrary here. I think what's notable is that there two things were going on with these particular 5 FOIA requests. There were 2 sort of simultaneous appeals to Director Washington. And clearly the fee, one of them for each FOIA requester was for a fee reduction. And the department responded to that, and the statute is very clear. It gives very clear directives that you have 45 days after you appeal to the director of the public body to reduce the fee.
Well, let me ask you this.
Bring an action.
I think they're going to take umbrage at your framing of this, because I think their position is, if you look at the way MDOC responded, they said it's granted in part and denied in part. And they take the position now that the real problem is that it was denied in part and they're being deprived of an opportunity to be heard on that. Now, I think you're probably going to tell me, if you look at what Ms. Washington said, she said, we haven't made a substantive decision. We just haven't processed anything yet because you didn't pay your deposit.
Correct.
Well, talk to me a little bit about that, though, because I know they say this isn't a fee dispute. I tend to disagree. I don't know how you get around exactly what the director said, which was the last word on this before it came to us, or came to me. Sorry. Now I'm used to speaking in the plural because I'm on the Court of Appeals, but I'm just me now. Before it came to me, the last word on it, I think, is this document that Ms. Washington signed on April 10th, 2023, right?
Correct. I don't know if it's a different date on each or. if
Well,
it's-
right. I'm sorry. I'm just using the first one as illustrative.
Okay, yep, April 10th.
And then the Freedom of Information Act complaint was filed on September 28th, 2023. And I take it your view is the period, I think it's 45 days,
Correct.
came and went from April 10th before we got to September 28th, 2023, right?
Correct.
Right. So speak to what I know I'm going to hear from opposing counsel, that there was in fact a denial of the request. And that was something that could be brought to us, not as an appeal on a fee determination or a deposit determination, but rather a merits determination.
Well, I think the two cases that you reviewed and that you were a panelist on, Michigan Record Company, speak to my answer on that. I mean, it's very clear from Michigan Record Company that that does not constitute a denial. That language, in fact, I think that language was used, at least similar language, if not exactly the same language, was used in the Michigan Record Company case by MSP, and the Court of Appeals decided that that isn't a denial, and that the prerequisite, right, is that you pay the deposit, and none of that was done in this case.
Well, let me ask you this, because if you go back to the document style as Michigan Department of Corrections response to request for public records, FOIA, and again, just use the first one, the one by Mr., I think it's a Mr., I don't know whether it is or not, Fujimoto, okay?
Okay.
If you look at that one, March 20th, 2023, it says the following action has been taken in compliance with the Michigan Freedom of Information Act. The first box is request granted, not checked. Down a little ways, there's something called request denied, and then the bases have to be checked. That's not checked. The one that's checked is the one in the middle. Request granted in part / denied in part. Checkbox, number of pages, 151. Portions of requested records are exempt from disclosure. See explanation and fee assessment below. So it's a little bit puzzling, because it seems to suggest that somebody's already made a determination that some of the records are exempt from disclosure, but they don't say how or why. I mean, if all we were working from is Ms. Washington's ultimate response to the appeal, I'd say that you're 100% winner, because the way that Ms. Washington describes it in the text, never mind what's in the form, to me is just clear as day. We haven't processed anything. We haven't done anything because you didn't pay, in the case of the Fujimoto request,
Right.
the $49.24, which was the 50% good faith deposit.
And in the response to request for public records FOIA for Mr. Fujimoto, I believe that's the one that you're looking at.
Yep. I mean, you can pick any one you want. That just happens to be the first one.
Right. In the middle section, after a 50% good faith deposit is required, under that, it says see below and back of form.
Right.
In that second paragraph, the last sentence of that second paragraph specifically tells the requesting party, Mr. Fujimoto, that once the deposit's received, the department will issue a written notice within approximately 60 business days, which does not include weekends or holidays, concerning the balance due, exemptions from disclosure, if any, and your remedial rights, if applicable.
All right, I see what you're saying. So,
So,
you're
I
saying-
mean, I
yeah,
think I think what I can speak to in terms of the FOIA coordinator with this particular request is that, you know, they obviously make an initial, some type of initial viewing, right, of what we're looking at, what we're potentially looking at. But that's, I think, the point of the good faith deposit is that once the requester sends that in, then the FOIA coordinator and analyst can go through and determine whether there's actually exemptions and what those exemptions are, what exemptions they're taking, you know,
Right.
how to process the entire request. And that's why, you know, I think the language is kind of saying request granted in part and denied in part. They're not denying the FOIA request outright, saying, you know, we're not gonna, you know, fill this. They're saying, well, here's the number of pages, at least to whatever they can see.
Right.
And give us a
So
good
wait,
faith
so, okay.
deposit, and then once we get that, we'll process it and we will give you your, you know, we'll tell you what exemptions, if any, we're taking.
Well, help me understand that, because I think I now understand better what you're trying to tell me than I did when I read the briefs. I think what you're trying to tell me is, in the case of Mr. Fujimoto's request, for example, or the Fujimoto request, I don't know whether it's a Mr. or Ms. That the identification of the number of pages in the request granted in part, denied in part 151 means there are in total 151 pages, but you're taking the position, some of these pages may be exempt from disclosure. We
Right.
don't know yet because we haven't reviewed them. So in
Right.
other words, the largest raw number of pages there would be to disclose would be 151. But don't be disappointed if you only get 126, because we may claim exemption on 25 of them. Is that the way to read it?
Right.
Okay, and so then what you do is you set the 50% good faith deposit at 1/2 of the gross number of pages, and that's how you come up with that number.
Yes, they have a bill calculation that follows that form.
Yeah, right, and I
Yeah.
did my best to try to make sense of all of these.
And so I don't wanna misstate what the FOIA coordinator would say, you know, as to each of those, but they have a calculation that they provide each, in each response to each requester.
Right, well, would you speak for a moment too to this notion of what an excess fee is? Because I can read MCL 15.240 small a, and it talks about fee in excess of amount permitted under procedures and guidelines.
Sure.
When I think of an excess fee, I typically think of something that'd be in the thousands of dollars or the tens of thousands of dollars, such a large amount that it would inhibit somebody's ability to even go forward with a FOIA request. When I went to the particular forms here, I was stunned at how low the numbers were. I mean, I think the largest one wasn't even $75, and some of them were in the $20 to $30 range.
Right, so.
So
I
what,
think-
what does excess mean? Does excess just mean anything that exceeds the amount that the FOIA agency can actually charge?
Well, in this case with the Department of Corrections, they have adopted procedures and guidelines. And for the MDOC, if the amount exceeds $50, then they can ask for a 50% good faith deposit before
Right.
processing.
Right, and all
Yeah.
of those fell into that category. But what I'm asking you is, if I'm trying to, let's say that they had chosen to go to court to challenge these fees as excessive. It doesn't seem to me that any of these numbers are excessive, but is it possible that a fee could be excessive even if it's $40? If, for example, they said that it was gonna be, there were only 4 pages and it was gonna cost $10 per page to copy them.
Well, I think in response to that, the department is based on the affidavit of the FOIA coordinator, Mr. Phelps. I believe they take the position that if the estimated amount is over $50, then they will ask for a good faith deposit. I think what your question turns on is if it's less than $50, will they still ask for a good faith
Oh, no,
deposit?
no, I'm sorry. I used a bad hypothetical because I came to $40. Let me change my hypothetical slightly. So we're over the $50 threshold. Because I'm trying to figure out what it means for something to be excess. Let's say there are 6 pages now and they want to charge $10 a page for a grand total of $60 to copy 6 pages. Can that be excessive?
Well, if you look at the bill calculation on each of these, they're charging 10 cents.
Right,
a sheet.
I'm not, right, I'm not saying that there's anything wrong with the calculations or the charges in this case.
Right.
They strike me as perfectly reasonable. But they hint, and they even say, I think, in a couple pages, where is that? Shoot, I got that in one of their pleadings where they talk about the fee dispute and they say, it's in the original one. In addition, the fees MDOC is attempting to charge are impermissible as explained above. And they seem to hint around that the charges are too great. And I'd have to find that language. Yeah, the unreasonably high cost language. Because I'm just starting to get my arms around the facts of this case, but there's nothing about this case that causes me to think that the fees are in excess of anything, either that which is reasonable in a freestanding sense or that which is permissible under FOIA itself.
Well, Judge, I hesitate to jump in without being invited, but maybe I can help.
Okay, well, I'll tell you what, Ms. McCormick, let me put it this way. I'll give you time to come back again, but I think most of my questions are for Mr. Cresta. Anybody who saw me in my 14 years as a circuit judge knows that motions, I try to speed things up a bit by coming out and telling you, I've done a ton of reading. I have a pretty good idea of what should happen here. And this happens to be one of those cases where I came out and basically said, MDOC's going to win unless Mr. Cresta can convince me that I'm way off in my thinking. So why don't I give him a chance?
Thank you, Judge.
Okay, all right, go ahead, Mr. Cresta.
Well, Judge, good to see you, and thanks so much for your thoughtful inquiry, and I'll do my best here. So many places to start with this, but I think what's fundamentally important based on what you've said so far is that it would be a very big mistake to look at this case and say, oh, I've seen this before. This is Arabo. This is Michigan Records, because this case isn't either of those. And the reason it's not either of those, Judge, you've actually...
Right, well, hold on, Mr. Cresta, because I do want to tell you one thing. When I was on the panel in Michigan Records, they said, oh, this isn't anything like Arabo. Arabo doesn't even apply anymore because they amended the statute. And of course, we said, no, 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 this is Arabo. And so I think this is Arabo and now Michigan Record too.
Well, I would agree with you that Arabo and Michigan Records are similar, but I think it's different in this case. And you've actually already identified why they're different, Judge, and that's because of the response that was given by the Michigan Department of Corrections. So now in Arabo, the Michigan Department of Corrections said in their initial answer, we are granting your request as to all non-exempt public records, okay?
Right.
And the Michigan Records case, actually, that was a really bizarre set of facts. I'm sure you already know, but they didn't respond at all. They didn't get a response at all, Judge.
I know,
So he sued. Okay, this case is different. In each one of these, the department responded with, your request is granted in part and denied in part. And if you look at section 5.5 of the statute, it specifically says what that means. Section 5.5, a written notice denying a request for a public record in whole or in part is a public body's final determination to deny the request or a portion of that request. And the written notice must contain, and this is section 5A, an explanation of the basis under this act. And Judge, it goes on to say, you need to say what exemptions apply.
But just to be clear, Mr. Cresta, I agree with you that the form is unnecessarily confusing, and it bothers me that it says what it says. But if you go to Ms. Washington's response in the Fujimoto request, from April 10th of 2023, that paragraph I read at the start, I mean, it is so patently obvious what position MDOC is taking. The position they're taking is, we've identified the records, we've got 151 pages. We haven't looked at them yet, so we have no idea whether we'll be claiming exemption on some, all, or none, but you got to pay the deposit and then we'll do that process and then you'll get what you get. And if we claim exemption, we'll claim exemption.
My issue with that, Judge, is that they gave us a final determination in their first response that was deficient. And their position is, this isn't a final determination. We don't have to give you a final determination. But under the language of Section 5.5 of the Act, that was their final determination. Now, we appealed it to them.
Right.
And this is another way, an important way in which this case is not Michigan records. If you go to page 11 of your opinion in Michigan records, a very important piece to the court's decision was that the plaintiff in that case literally did nothing.
Yeah, right. I know. I know.
We didn't-
It's a very odd case.
I know, and that's why very distinguishable. Here, we did do something. We timely appealed. Now, Judge, it's not a fee appeal. A fee appeal is governed by Section 10A. We are suing under Section 10.
Right.
Okay.
Yep. Mhm.
Section 10A, the fee appeal, that's when your request is granted and they say it's going to cost this much. And you say,
Right.
that's
I agree
too
with
much.
you. I agree with you. I agree with you.
That's not here. We say you have denied our request and you want us to pay. And I go through the statute that I've got here. And what Ms. McCormick, the process she's describing, the process that was employed by MDOC, it does not exist in the four corners of this act. It's not there. And the way they're getting there is by blurring these lines and kind of meshing together a fee appeal and a denial appeal, using this magic language. Well, it's not denied, but it is denied. Well, non-exempt records are not denied. And what we need to do with this case, in cases like it, is get back to what the statute allows the department to do. And Judge, I'll just say, my client, the American Friends Service Committee, has been around a really long time doing
Right.
prisoner advocacy work.
Right. Yep.
And Judge, the process, for years, they've been making FOIA requests to the department.
Right.
What the department is doing now is a departure from what its traditional practice has been. So this is not an example of, well, they've done it this way forever. No. This is new. And it's problematic for a lot of reasons.
Well, what's new about it? Because I'm trying to understand what's process and what's substance here. Because as far as I can tell, each one of you is accusing the other one of putting the cart before the horse. What they're saying is, we got your request. We've identified the total number of documents that would be responsive to your request. We haven't gone through them, but we will as soon as you provide your 50% deposit, and then we'll claim exemption on some documents or not, and you'll get everything else. So they say they have responded to you. You say, no, you haven't, because you said you granted it in part and denied it in part. And what that suggests is they've already made some determination on the merits that some of these documents are subject to exemption and some are not. And yet they haven't given you anything, nor have they given you an explanation for the ones on which they're claiming exemption. And this is why you're really talking past each other, because what Ms. McCormick and her client are saying is, we haven't looked at anything. We haven't made any determinations about what's exempt or not exempt. Pay the deposit and we'll do that for you. And you're saying, you already said you did.
So a couple of things, and I'll try to address. You raised a lot of good points there. First, they are supposed to already have records. And this is the law. Under the statute, they are supposed to have their records in a format that they can identify and access. And that's why the statute doesn't allow any charging for sorting or finding the documents.
Right,
All
sure.
the things they charge in here, right? You're not under the general rule. You can't charge for that. because you're already supposed to keep your records, right? Have your house in order.
Absolutely, absolutely.
Now what they're doing, the way it's a departure, before it would be, they get the request, the statute lays out the process. They have 4 options of what they're allowed to do: deny it, grant it, deny in part, grant in part, or ask for more time. That's what they're allowed to do.
Yep.
They've done this new thing where they say, well, and this isn't in the statute. We get a request, we say denied in part or granted in part, or we say something like in a RABO, right? Granted us to non-exempt public records. Then we have you pay us, and then we go in and decide what exemptions apply.
Correct.
And my problem with that is nowhere in the statute. They point to the charging of the fee.
Yep.
Can be charged prior to producing the records.
Mhm.
And you had said, I don't think these amounts are very high. Well, Judge, I don't disagree with you. We're not saying that $50 is too much.
Right.
Our problem is we don't have the faintest idea what exemptions they're alleging, what documents we're going to get, but they want us to pay first. And the problem is the statute doesn't provide for that. If they tell us, we've looked at the documents, the 100 pages, and we've taken these 25 out under this exemption, and it's going to cost this much if you want the other 75. Well, that's really the process. That's how it's supposed to be done. Right now, we're just flying blind. And again, I've said it, it's not in the statute. The language they're talking about, the language for RABO.
But when the statute was amended after a RABO, I think the legislature did 2 things. One, they got the sequencing for this good faith deposit cleaned up in Section 8. And second, I think they made it clear that they don't have to request the deposit right out of the box. They can do it at various times. It used to be much tighter. Now it says in either the public body's initial response or subsequent response. And if you go back to the statute in a RABO, it just said it had to come with the initial response. And then the other thing I think, which is really clear about subsection 8 of MCL 15.234 is that the sequence that they've laid out here is exactly the sequence the legislature intended. In either the public body's initial response or subsequent response, the public body may require a good faith deposit from the person requesting information before providing the public records to the requester if the entire fee estimate or charge authorized under this section exceeds $50, and in this case, all of them do, based on a good faith calculation of the total fee described in subsection 4. And I don't understand why you believe what they're doing here is inconsistent with that statutory language, except for this odd little box they have, which says it's granted in part and denied in part. I mean, I'll agree with you. The fact that that box is checked is a real head scratcher.
If you look at what they're allowed to charge fees for, Judge, if you continue reading on,
Sure.
you'll see that all the things they're charging for, they are not allowed to charge for, except for in certain circumstances. And you were asking the question earlier, like, well, $50, I mean, that doesn't seem excessive to me. Well, it doesn't seem excessive to me either. But the question is, they're not allowed to charge for any of that because it's really not that much money, Judge. That's why that should be built in to what they do. And when you ask them, well, why are you charging? Judge, they're charging for every single request. And that's the exception to the rule. And if it's the exception to the rule, how can you charge for every request? Now, I'm sure Ms. McCormick will be quick to point out, how does he know they're charging for every request? He doesn't know. So to be fair, I don't know that. I'm just saying, in our experience, they are charging for, they're taking the exception, and it's really the rule now. If it's not every request, it's darn near every request they're charging before they're giving you any answer. And that's counter to the purpose of this statute, which is to make records accessible.
Well, I'll agree with you that the overarching principle of FOIA is that public records are supposed to be readily available. There's no question about that. But one of the frustrations I'm sure MDOC has is that of all the agencies, I would imagine they're overwhelmed just about as much as any agency could possibly be with FOIA requests. So they try to routinize them to the very best of their ability. But it doesn't seem to me that this is price gouging in any way. They're simply saying, give us half of it up front and we'll take care of everything you want.
It's not price gouging. It's not price gouging, Judge. They're doing just enough, right, to disincentivize you from proceeding. These records, we haven't even said this yet, but I mean, under the statute, Judge, these are public records by definition. This isn't, right, these are parole records that are by statute defined as public records. So if they want to make their job a little easier, because I'm sure they get a lot of requests, then they should hand over the file that's been requested. It's all in a file. I don't think it's price gouging. I don't think they're trying to line their pockets. I think they know that if they charge this good faith deposit on all of them, I bet 8 out of 10 people just walk away.
Well, right. I mean, look, I ran a federal public defender's office for 7 years. We sent out more FOIA requests than just about anybody on earth because you want to cover the universe and make sure you get everything you get. But one of the things we realized was we'd have to pay a deposit every single time before we get any paper.
Mm-hmm.
And what you're suggesting seems to run contrary to what I believe to be the ubiquitous practice in the United States, that if you want to get records, you got to pay something up front, and then they'll trust you to pay the rest of it if there's more at the back end, but they don't want to get stiffed every time they send records out.
No, I'm not saying it's free. You have to pay to get the records. Okay, let's not even quibble about whether the amount here is appropriate. I agree with that. You point to that section 4 sub 8 and you say it says they can make the request at any point. And that's true, but Judge, it doesn't say that they don't have to give you a final determination before you pay. It says they can request it.
Right, but Mr.
And if you go on, there's another.
Mr. Kress, I think you're reading way too much into that oddly worded checkbox, because it seems apparent to me that they've made no determination that they're claiming exemption or not on any individual piece of paper in the file. They've just identified a gross number of pages. They've done their calculation based on the gross number of pages. They're waiting for the deposit to come in, and then they'll go through and decide where they're going to claim exemption and where they're not.
And they are not allowed to do that. That's my position. They can't do what you just described, which I agree with you. That's exactly what they're doing. You can't do that. That's why the statute prohibits charging for this sort of thing. And that's why the statute has a really tight and strict timeline on when you can respond and how you have to give them an answer. What I was going to say before, judges, there's the one section that you cited, which says they can make the request at any point, initial request, response, or
anytime.
But later on in the statute, and actually the language pre-Arabo was even stronger. The legislature took that out. But later in the act, they added language, and I'm just trying to find the exact part, but it says that, here it is. This is section 4.8. They can charge the good faith deposit before providing the public records. So they can make the request at any point. And that's true. But the requester is entitled to an answer prior to paying the deposit. They're not required to pay. They're not entitled to the documents before paying the deposit. And that's what the new language in section 4.8 is saying. Before providing the public records. Judge, if it was as MDOC says, and it's before rendering a final determination, then that's exactly what the statute would say, but it doesn't say that.
Okay.
They do have to do some work up front, and I know it's a burden, right? But this is transparent government. They have to do some work on the front end to determine, okay, what do we have? What can we produce? What can we not? And Judge, but they can't do that for every single request. Okay, only in certain cases, and they can't withhold their final determination pending a payment. The statute doesn't allow that.
Well, what they can do is they can hold production pending payment,
Yes.
right? I mean, we all
Yes.
agree on that.
That's
What you-
exactly right.
So what you're saying is they have to do the work up front and then either make a decision to deny in part, to deny in whole, or to simply agree in whole, right?
That's right. You say do the work up front. I mean, I'm not saying they need to make copies and.
No.
I'm just saying
The
initial-
analysis, sorry.
I do
Analysis,
believe
right.
the analysis, and that this is what the statute requires, that they get the request, they can ask for more time, but they do it when they give you a final determination, which they have to do within X days.
Right.
Ms. McCormick earlier said, well, then we wait 60 days. We'll tell you in 60 days. And I would just, well, where in the statute does it give you 60 days? That's an arbitrary, could they say 365 days? The statute gives a specific timeline specifically to prevent what Ms. McCormick's saying. And Judge, you might say, well, 60 days is pretty reasonable. And I might think it's reasonable, but
Right,
that's
if it's not, right.
that's not the inquiry. The
Right, if the-
legislation
right,
didn't
if the
say reasonable
statutes-
time.
Right, if the statute says 72 hours, it doesn't matter what we think is reasonable. If it's 72
that's-
hours, it's 72 hours.
That's exactly my point. And we are saying this idea that you can give a preliminary determination. I made that word up, but that's really what I think Ms. McCormick is saying. We gave them a preliminary determination. It doesn't exist. That is a made up, that's a made up thing. You need to give a final determination. In section 5.5 tells us what constitutes a final determination. And with Arabo, and then the amendment, and then the Michigan Records case, which you all did a great job, but it was a bizarre set of facts. We now are in this situation where agencies like the Department of Corrections, I believe, think they have carte blanche to take as long as they want, charge whenever they want, charge for whatever they want. And that's not what the court has previously said, and that's not what the statute says.
Okay, Mr. Creston, let me ask you a question because I was puzzling over this. I don't think that any mistake of a requester in FOIA is fatal in the sense that, and I'm not trying to get myself off the hook, but if I determine that summary disposition for the defendant is appropriate under 2.116C4 here because of the problem that we've been discussing, there's nothing that prevents you from requesting again, starting the process over. And there's no such thing as res judicata or collateral estoppel with respect to a FOIA request. You can just turn around, do the same thing all over again and get the records, can't you? I mean, assuming that you can get to a point where you provide the deposit or whatever else might need to be done to get the records.
I think that's right. Yeah.
Okay, right. I just wanted to be sure about this because
Yeah.
Look, fundamentally, if somebody wants to challenge a ruling on commutation or parole or anything like that, it's impossible to do that if you don't have the records. I'm sympathetic at the most fundamental level to your position. You can't meaningfully do what you're trying to do, either as the prisoner or the requester on behalf of the prisoner, unless you get the records in your hands.
Right. Right. And yes, that's right, Judge. I mean, I have other things I would say, but I don't want to abandon you. I want to answer whatever questions you have. I have other
Okay.
things that I would say, not on that point, but in general, but.
Okay, and go ahead. I don't think you have to worry that much about standing. I mean, I understand what they're saying. I don't want to be hyper technical about standing. Would it have been helpful if these University of Michigan students had said that they were acting on behalf of AFSC? Of course it would have been.
Yep. I don't think it's fatal. I think if you look at the appeals, I'm sure you saw it in our brief. I put a little clip in there. I mean, on the appeals, it expressly says American Friends Service Committee.
Right. I
So
know.
they know, and I think the question is, how did this prejudice the department at all? Well, it clearly didn't. And would it have justified a different result had they done it that way? No, it would have been the same because they knew it by the time the appeal came around. So it really is a form over substance. And because in the appeal, they cited the requester, they were clearly operating as agents. So that's all I'll say about that.
Okay. Anything else you want to say? I mean, you'll get another chance. You get the last word.
No, I think Miss McCormick gets the last word. I mean, I am moving under.
Oh,
to
no, no,
Department
I'll,
6.
I'll give you the last word. I actually
Oh, okay.
let everybody argue twice.
What I was gonna say is, and I know that I have said this, but just very briefly, you spoke earlier about what is an excessive fee, and you were saying these fees aren't excessive, and this is the department is allowed to charge a good faith deposit if not doing so will cause them an excessive cost. And so when you ask them and you say, hey, these are pretty basic requests, it's a file, why is it going to cost? Their response is, well, somebody would have to stop what they were doing and respond to the request. I mean, that's literally what they said, right? Somebody's gonna have to stop doing what they're doing and respond. That cannot be the standard. That can't be the standard because that would rewrite the statute. Every single request, someone has to stop what they're doing and answer it. So I think that's really important to point out. And with that, Judge, I'll stop.
Okay, thank you, Mr. Cressa. Anything else you want to say, Ms. McCormick? And then if you say something, I'm going to give Mr. Cressa one more shot.
I'll stand on my brief and the language from Michigan Record Company, which specifically supports, frankly, the process that MDOC used here, besides the box that you've already pointed out, Judge. But in terms of the process and asking for a good faith deposit
Right.
up front, our position is that follows the statute.
Am I right that they can come back again and
Yes.
make another FOIA request?
At any point, they could have done a follow-up. And in fact, I think at least one of the parolees that were requested by a different student, there has been a subsequent FOIA request made. I don't know anything about the status of that, and I'm not involved in that, but I think counsel and I have talked about that.
Right, because, hey, look, I'm not telling anybody how to do their job. 16 years ago, when I took the bench, I stopped being a practicing lawyer. But as far as I'm concerned, the goal is to get these records in the hands of these people who are trying to get released from prison. And however that's best accomplished, it seems to me that would be job one.
Mm-hmm. Mm-hmm.
Okay, well, Mr. Cressa, Mrs. McCormick said a few things. So if you want to say anything in response, feel free to. And then I'm not going to decide this one from the bench. I'm trying my best to make sure I understand everybody's arguments. I really like hearing oral arguments because I always learn quite a bit, but I don't want to pull the trigger on something if I'm not fully confident about how I want to say it.
Yeah. I don't think I have anything further, Judge. I appreciate you giving me the time to respond. I'm sorry. There was one other thing I didn't mention. I see in my notes where I would just say. Sure. Michigan records, to the extent you're looking at Michigan records, Section 414, Michigan records was ultimately dismissed under Section 414 of the statute.
Yep.
Because he didn't do anything. We talked about that earlier.
Correct.
In Section 414 says you can either appeal or you can sue, right?
Yep.
Or both. And in our case, we did appeal. And this is just one more way that we are different. And so we justify a different result. But I don't think I'd mentioned Section 414, but I think it's worth looking at. And with that, unless you have other questions, I appreciate you taking the time.
No, thank you very much. I really appreciate everybody's input today. As I said, I find oral argument invaluable. I try my very best to hear oral argument every single motion I have. And I'm glad I did today because I understand your case much better. So thank you both very much. And I'm not sitting as a judge on the Court of Appeals in April. So I'm devoting the next 5 or 6 weeks to Court of Claims exclusively. And so you should have a decision very quickly. Okay.
Thank you,
so
Judge.
much.
Okay.
Thank
Thanks
you,
so much,
Tyler.
everybody. Yep. Thanks so
Bye.
much.
Thank
Bye.
you.